So we'll be discussing the Indian Partnership Act, where our plan is to actually give an overview of the entire act, mainly with respect to the concepts and aspects and terminology of the act. And it won't be very clearly with respect to every section specific, but we'll give an overview of the basic provisions of the act so that you get a general understanding so that you can delve deeper when you do study. So the basic features of the act as such to start off. First, we'll define a partnership. So the act defines partnership as a relation between two or more people who have agreed to share profits of a business carried on by all or any of them acting for all. So the main aspect here is that it has to be two or more people. They have to have a sharing of profits of the business and everybody acts for themselves and for each other. Now, the way a partnership is formed, it has to have an agreement between the partners, which can be written or oral. However, as we've all studied in law, it's always advisable to have things in written. Therefore, having a written partnership agreement helps to avoid disputes, and it can also define your rights and obligations in a clear format. Now, as I said in the beginning, for a partnership, you have to have minimum two people. That forms your partnership. There's no maximum limit on the number of partners, but there are certain professions where restrictions will apply. Apart from that, if you have two or more people, you are eligible to start a partnership of your own. Moving further, one key feature of partnerships is mutual agency. Now here, as I said before, a partner works for himself and for all. So therefore, he's an agent and a principal both, meaning he can bind the partnership and each other through their own actions within the scope of the partnership's business. So for example, if there are three partners and one partner is acting differently from the other two, but acting for the partnership itself, the other two also get bound by that because they're all severally liable, jointly and severally liable, sorry. Moving further, partners have unlimited liability, which means that anything that happens in the partnership firm with respect to debts, obligations, profit sharing, loss sharing, partnership debts, the personal assets of the partners are actually used to satisfy the liabilities, which means that if the partnership proceeds or the funds in the partnership are unable to actually meet the expectations or requirements, then the personal aspects of the partners will come into play in this aspect. And sharing of profits and losses, as said, if there is no agreement, then the sharing of profit and losses is done equally. However, if there is a partnership agreement, then of course the agreement will actually detail what the profit sharing ratio will be, profit and loss sharing ratio both. Moving further, since a partner is actually, as we said, jointly and severally liable, there are obviously implied rights and duties that a partner has to fulfill while he is in a partnership firm. This refers to right to participate in the management of a business or duty to act in good faith, because again, you're bound by one person's actions for all of them. You have a duty to indemnify for losses caused by willful misconduct, and so on and so forth. Another two basic features actually regarding dissolution and registration. So ideally, registration would come first, but in that sense, what we'll say is that in the act, it is not mentioned specifically that you have to mandatorily register your firm. But of course, being an unregistered partnership firm, you'll have certain disadvantages. You cannot sue in your own name. You cannot file a suit against a third party. Therefore, in general, it's always recommended to actually get your firm registered, the same way as it's recommended to have your partnership agreement in writing and not oral. And then dissolution as such is when the partnership firm actually has to be dissolved, in that sense, broken down or stopped. So there are various modes that are given in the act, like mutual agreement, expiration of fixed terms if the partnership is for a specific reason or term, death of a partner, insolvency of a partner. We'll delve upon this point and registration also actually further on in the PPT as we go forward.
Coming to the nature of partnership, so there are four basic elements to form a partnership and a valid partnership. The first one is there has to be an association of two or more persons. Of course, for any partnership to come in place, there have to be two or more persons. That is the first main feature. Second feature is that there has to be an agreement between parties. So this agreement has to be a valid contract, because the very foundation of partnership is a partnership deed or an agreement between partners. So all the elements for, or all the ingredients for a valid contract have to be met in order to have a valid partnership deed and a valid partnership agreement in place. The third basic feature and the most important feature is the mutual agency. Now, this is the true test of partnership, because every partner in a partnership firm is an agent of one another to the extent that he can bind the other partners of the firm for the acts done in the name of the firm. And he is a principal to the extent that he is bound by the acts of other parties. So I think this is a very important and repeatedly asked questions. I think mutual agency has also been dealt with in the definition of partnership, because the definition of partnership in section 4 says that it has to bind all the partners. Now, the next basic feature is that the business that is carried on by the partnership firm has to be carried on by all partners or any partners acting for all. The other important element is the profit sharing. Of course, any partners who come together and form a partnership, their objective of coming into partnership is for profit sharing. So not necessarily that they have to share losses also, but that depends on the nature of partnership and the terms and conditions that they have agreed upon. But if there is no profit sharing in the first place, there is no partnership. Now, the business which the partnership may carry on may be temporary or permanent. That will be discussed later on, because there is particular partnership, there is general partnership, there is partnership at will. Then there are some kinds of partnership where they only come together for a specific purpose, and once that purpose is over or that objective is achieved, the partnership is dissolved. Another important element of partnership is that the partners have unlimited liability. Now, any acts of the firm which the partners have carried on in the name of the firm or in the ordinary course of business of the firm. So the important element here is that the partners have to carry on business in the ordinary course of partnership, which means that any activity which the firm is carrying on, or any activity relating to the business that the firm is carrying, that is what is known as ordinary course of business. Now, of course, we have joint ownership also, because the partners collectively own the assets of the firm. Now, if supposingly today Yazad as my partner is purchasing a property in the firm's name, that property will go to the assets of the firm, which all the partners of the firm will jointly own. So it will not be exclusively his property, but it will be property of the firm. Then next feature is the transferability of partnership. So unlike shares in a company, a partner cannot transfer their partnership interest to an outsider without the consent of all the other partners. However, a partner can transfer their rights to receive profits or their share of assets upon dissolution. So of course, this point will also be covered in the dissolution aspect, but basically this comes in your points of difference between a company and a partnership, which is also a very important question, which is repetitively asked by Mumbai University. So you have to know the difference between partnership and a company. You have to know the difference between partnership and a Hindu undivided family. So all these are very favorite questions of examiners. The next element is continuity. A partnership does not have a separate legal existence from its partners. It is not a distinct legal entity like a company. Therefore, the partnership is dissolved upon death, insolvency, retirement, insanity, or other things, as Yazad already mentioned. Now, as I said, these four elements of a partnership are very important. So when you're asked a question as to nature of partnership, you have to mention these four key features and you have to elaborate them.
Now, moving further, we'll be discussing relation of partners in two ways. I'll be dealing with partners, the relation between one another, and Ruchi will be discussing the relation of partners to third parties. So when it comes to relation of partners to one another, as in between them or amongst them, if it's two or more, in this, some key points that are there are mutual rights and duties, mutual agency, and equal rights and participation. So all these three actually can be looked at together to basically say that everybody acts on behalf of each other. So when we look at mutual rights and duties, we see that the partners are considered co-owners of the business. They share the profits and losses, as we've said before. They have a mutual duty to act in good faith, carry on the business with utmost fairness, loyalty, and honesty. This goes simply because of the fact that one person's actions can actually affect everybody. Mutual agency, meaning they act as agents of the partnership firm. Say, for example, if Ruchi, myself, and X are three partners in a firm, and X goes and does something on behalf of the partnership firm, as in he represents himself in a certain way on behalf of the firm, as in as an agent of the firm, then Ruchi and I also will be liable for the actions done by that person. And equal rights and participation. Now, as we said at the beginning, if you have a partnership agreement in writing, Then you will specify what are the rights you have, the profit sharing ratio, loss sharing ratio, remuneration, if any. All those aspects will actually come into the agreement. If there is no agreement, as we said before, they get shared equally. So as it said here also, unless otherwise specified in a partnership agreement, the partners have equal rights in the management and conduct of a partnership business. They also have an equal say in the decision-making processes. Now, just to sum this point up, if you do not have an agreement, it gets shared equally, which goes on the same footing as even if you do have an agreement but do not specify it, then naturally it still gets shared equally. That is the entire point. Moving further, all partners have a fiduciary duty to each other, which means that they have to act in the best interest of the partnership. They shouldn't make secret profits, compete with the partnership, or disclose confidential information to outsiders. Now, this fiduciary duty point will come into any aspect, whether it's a company, it's a partnership, it's a limited liability partnership, XYZ. It wouldn't come in a sole proprietorship, obviously, because there's only one person. So you don't have a duty to anybody else. But in a partnership, it follows the same way, that there shouldn't be any insider trading, any secret profits, any of these things happening. Then indemnification, a partner is entitled to be indemnified by the firm for payments or liabilities incurred in the ordinary course of business. As Ruchi mentioned before, any act which is being done in the ordinary course of a partnership, as in for what that partnership firm has been made for, then the person who is that relevant partner will be indemnified for it and can also get reimbursement of personal funds which have been used for partnership expenses. When it comes to remuneration, as said before, if your agreement mentions remuneration, then you actually can draw a salary. There are many partnership deeds which we actually see in practice where there may be 4 partners and 3 of them are drawing a remuneration and 1 may not be drawing. There, that person may be called a silent partner or may not be that actively involved to actually get a remuneration. But having said that, the fact that the person still is a partner means that they have all the rights and liabilities and equal responsibility for the partnership as a whole anyway. And dissolution and winding up, I don't think we'll mention this point again right now because we'll deal with it when we actually come to it later. The entire process of dissolution of the partnership firm.
Now we come to relation of partners to third parties. Now, this is a very important aspect of the Partnership Act because when you are coming together, forming a partnership, what liability will you have or what would be your relation to third parties is something which we are discussing right. So first, very important feature is that the authority of partners, which is an implied authority, because there is an agent and a principal relationship between the partners. So every act which a partner is doing as an agent of the firm is all the other partners are bound by his act. This means that each partner has authority to bind the partnership and other partners by their actions and contracts within the scope of partnership business. Again, what is important to note here is that all the acts which are carried on should be in the ordinary course of business. Now, as partners of a firm, they can do many acts like hiring any goods or buying any goods on credit or say instituting suits or defending suits on behalf of the firm. So all of these acts which can be done by partners are obviously not expressly mentioned in the act, but if you read the provision of section 19, you will come to know that this implied authority, there is a scope of this implied authority and the Partners Act should be within that scope. So the scope of implied authority obviously would be this only, that the act which is carried on by the partner should be in the name of the firm or while acting for the firm for any business which is done in a usual manner, which the firm would do in its usual practice. So this is all about implied authority. Now again, act of partner binds the firm. All that is discussed. Now, liability for wrongful acts or omissions. Now, if supposingly Yazad and I are in a partnership and I am doing any fraudulent act or any unlawful act with a third party, will Yazad be bound by my acts? The answer is yes, only if my act is in the usual course of business. Now, if I'm doing anything otherwise personally at a very personal level, Yazad will not be bound by it because my act should be in the firm's name or while representing that I am doing something for the firm. So this is all about wrongful acts or fraudulent acts done by partners of the firm. And for such acts, the partners can also be personally liable in the sense that their personal assets can also be sold or can also be realized for the purpose of satisfying debts or any other purpose. Now, liability for debts and obligation, again, partners are jointly and severally liable for debts and obligations of the partnership. This means that if partnership assets are insufficient to cover the debts, creditors can hold individual partners personally liable for the outstanding amounts. As I already said, your personal assets will come into play. They will be sold. The sale proceeds will be realized to pay off your credit. Now, notice to the firm. This is a very important feature in the sense that any notice or knowledge of anything which a partner will have, that will be considered to be a notice to the firm, because as already mentioned earlier, the partner is an agent of the firm. So if you recollect the provisions of Contract Act, in that it is specifically mentioned that any notice given to agent will be considered as a notice to the principal as well. So any notice given to the partner is notice given to the firm. Incoming and outgoing partners, liability of an incoming partner is limited to his share in the profits and losses of the partnership unless there is an agreement to the contrary. So if your partnership deed or an oral agreement specifies otherwise, then his liability can not be limited or it can be unlimited, whatever your partnership deed says. And an outgoing partner continues to be liable for the partnership's obligations until the public notice of his retirement is given. So we'll come to this when we talk about retirement. Whenever a partner is retiring, he's supposed to give a public notice. So until the date of public notice, an outgoing partner remains to be liable, even if he has retired from the firm, but because giving of a public notice is a mandatory aspect for retirement, he continues to be liable for all acts done by him until the public notice is given. Now, there's also a provision in the Partnership Act that a person can also extend or restrict his implied authority, which is mentioned in section 20 of the Act. Also, there are other authorities or liabilities which a partner will have to third parties. One is that partner's authority in case of emergency. So in case of any emergency that the firm is facing, the partner's authority or liability, or rather say his duty, would be to protect the firm from the losses which the firm is incurring. Then the mode of doing anything which would bind the firm is that should be done in the firm's name, or there should be an intention to bind the firm or represent the firm.
So now we'll be discussing the points regarding admission of a partner. So in basic sense, admission of a partner refers to any partner, an incoming person who's entering into the partnership firm, or it could actually be an entire new firm being admitted as well. So naturally, for admission to happen, you require the consent. You need the consent of all existing partners. As everybody is liable for each other and everyone is working together. If there is a partnership firm of 3 partners and they want to include one more, all 3 have to be, in that sense, in agreement to actually bring in the 4th person. So consent of existing partners goes directly with the second point, which is agreement amongst partners. This mutual agreement has to be there. Your entire change in the constitution of your partnership, which is known as reconstitution of partnership, will also take place, where your new profit sharing ratio, your new terms and conditions, your entire new loss sharing ratio, if there is, your new remuneration, all those terms and conditions will be mentioned when a new partner gets admitted. And because of this, the partnership continues in the same way with the inclusion of a new person. So in my example before, if Ruchi, I and X are running a partnership firm and we want to include Y, in that sense, the person Y who comes in, the partnership firm will continue in the same way, but with this 4th person inside. And because an admission happens, your partnership deed, which actually existed before, it will require amendments to it. And because it is the legal document which is actually there, you will have a new reconstituted partnership deed which will be made, in which this 4th person, in my example that I gave, the 4th person who's coming inside, it will mention that so-and-so person residing at so-and-so place is now being included as a partner, along with the profit sharing, loss sharing, remuneration, terms and conditions that are there. And this amended deed obviously has to be signed by all partners again. So in my example, all 4 partners, 3 existing and continuing partners plus one incoming partner will all sign it together. Now, as Ruchi said before, if a partner retires until public notice is given, you actually are still bound and liable for the partnership. Same way, when a person is being admitted also, if you actually have an admission of a new partner coming in, you need to put a public notice which is given in the official gazette as well as one local newspaper which is circulating in the district where your principal place of business is situated. This is so that everybody on the outside, as in all third parties and the world in general, is aware that this partnership firm now from these three people is now four, using the example that I gave. And the liability of the new partner goes the same way. He is included as the person who has entered, and he's liable for all the acts of the firm incurred before or after admission. For example, if there is a new partnership deed coming in which says that the new partner, the incoming partner, is liable for all deeds of the partnership firm and all liabilities of the firm, for example, since inception, then it means that the person who's entering now is also liable for the liabilities that exist in the partnership firm before the time he actually entered, because he or she is also aware of what they are getting into, and that exactly gets detailed in your partnership deed when a partner gets admitted newly to the firm.
Yes, so here we come to retirement of a partner. But before discussing this, there are two important elements that I want to discuss. It is with respect to the liability of partners. Now, there is one provision in the Partnership Act which talks about liability by holding out, because I am only emphasizing on this because at the time of retirement, all the accounts are settled, all the liabilities have to be accounted for. So supposingly, liability by holding out means that it works on the principle of estoppel basically, and it means that whenever a partner, a person, not a partner, a person represents himself to be a partner or he permits himself to be so represented. So if I give you an example that if Yazad is a manager of my firm and I am a partner with some other person XYZ as another partner. Now, if he's a manager, we are going for a meeting, and if somebody is asking him, are you a partner of the firm? He says, he does not say anything, but I say that yes, he's a partner, and he does not object to it. That means he's permitting himself to be represented as a partner. Now, if that contract which is entered into with the firm, there is any liability arising out of that contract, then Yazad, along with all the other partners, will be liable because he has held himself as a partner, or he has represented himself as a partner. So in this case, in the case of liability by holding out, or otherwise, there may be one more case that supposingly he's a manager of my firm, but he himself is saying that I'm a partner of the firm, and he contracts on the basis of that representation, and the other person, the party with whom the contract is being entered into, they, on that belief that he's a partner and he has good reputation in the market, on that basis, if they are entering into a contract and there is any liability, then again he becomes liable. Now we come to retirement. Basically, for retirement, there can be voluntary retirement, which should be with consent of all the other parties. So when a partner is retiring from the firm, he would require the consent of all the other partners. And if the other partners do not consent, he cannot retire without reaching the partnership agreement. So obviously, when you're reading a partnership agreement, you will find a specific clause for retirement or what happens to the partnership in case of death. That obviously will be covered by Yazad later on. But yes, so a partner has a right to retire from the firm voluntarily if he wants to retire from the firm, but he has to take consent from all the partners. And the partnership agreement also specifies the notice period. Usually it does. Of course, it depends on case to case. It specifies the notice period which is required for retirement. So I cannot say that, okay, I'm retiring from today itself. There has to be a notice period that with effect from such and such day, I will retire from this firm and I will no longer be a partner of this firm. Now, if there is no such agreement, then a partner can retire by giving a reasonable notice period. What is reasonable is very subjective. Consequences of retirement. When a partner retires from a partnership firm, the following consequences may arise. One is liability, very important. When a partner is retiring from a firm, he continues to be liable for all acts of the firm until date of public notice of retirement. This I already mentioned earlier. that when you retire, you have to give a public notice in the official gazette and in local newspapers. So until you give this public notice, all the acts which are done by even by the other partners, because you're still a partner of the firm, and because of the principal agent relationship, you continue to be liable unless there's an agreement with other partners that releases the retiring partner from future liabilities. So if, for example, in the retirement deed, it is mentioned that you do not have to wait till the date of giving public notice, but with effect from today, that is the date of execution of this retirement deed, you are released and relinquished of all the liabilities of the firm. So then it is subject to a contract to the contrary, but in the usual course it is always until public notice of retirement is given. The next point again says that public notice should be publicly announced through a notice in newspaper. Notice serves to inform the general public about the partner's retirement and protects the retiring partner from future claims. Partnership dissolution. Retirement of a partner does not necessarily lead to dissolution of the partnership firm unless the partnership agreement specifies or the remaining partners mutually agree to dissolve the partnership. So this means that if a firm is consisting of, say, 4 partners, A, B, C, and D, if D decides to retire, A, B, and C can still continue the partnership business. And while continuing the partnership business, there may be terms and conditions which may be imposed on D, the retiring partner, that he should not continue in the firm's name, continue any business in the firm's name, or he should not solicit the customers or any clients of this particular partnership firm. So all of these terms and conditions would be specified in the retirement deed in usual. And obviously, if there's a retirement cum admission deed, then in that case, this is very important that at the time of retirement, all the accounts of the partnership firm should be settled. So if, for example, I'm retiring from the partnership firm, I have to be paid my share of profits. Or so obviously there are methods of evaluation or deriving of how much share should be given to me, but that again is a subject matter of a very different topic. So while retiring, but obviously the retiring partner is paid some amount which is equivalent to his share of profit in the partnership, which includes the capital contributed by the partner and share of profits and losses. So whatever contribution I am giving to the firm during existence of the partnership or while I am a partner, that obviously has to be paid back to me. The partnership agreement may specify the method of valuation, or it can be mutually agreed upon by the partner. New partnership agreement. After the retirement of a partner, the remaining partners may choose to continue the partnership by entering into a new partnership agreement. The terms of the new agreement, such as profit sharing ratio, management responsibilities, and decision-making authority, may be renegotiated. So as I said, while retirement, if there is another incoming partner, so one partner outgoing, one partner incoming. So in the deed of retirement cum admission, you all have to mention the specific ratios, all the new modalities, or if you are supposedly changing the nature of business, then all of that has to be mentioned in the same document.
Now coming to expulsion of a partner, which means a person, in very basic sense, a person being thrown out of the partnership firm. So a partner cannot be expelled from a firm by any majority of partners, save an exercise in good faith of powers conferred by contract between partners. Now, in very basic sense, this means that even if you have, say, for example, 4 partners, it cannot be a situation that 3 of them gang up and say the 4th person has to be expelled. This can only happen in a way in which as per the partnership deed or agreement between them. You cannot expel a partner just because, for example, 3 of them feel that the 4th person is not working or is not good enough anymore. So therefore we want to remove. There is a certain way in which the partner has to actually be expelled from the firm. And due to that way can only be by the agreement. It of course has to be exercised in utmost good faith. And if anything is done which is not as per the agreement or as per good faith or as per the prevalent laws which are existing, then it is called irregular expulsion. And in such a situation, the person does not cease to be a partner. So for example, if, as I said, if Ruchi, myself, X and Y have a partnership firm and 3 of us decide that X has to be removed. So in that sense, it will, and that is not as per the agreement or done in good faith. then X still remains and continues to be a partner itself, simply because he does not cease to be a partner, as we have not followed the provisions of the Partnership Act and the prevalent laws to get him expelled from the partnership.
Death of a partnership. So if a partner in a partnership firm dies, does the firm dissolve is a very important question. So the answer is here that the death of a partner automatically leads to the dissolution of partnership firm unless otherwise specified in the partnership agreement. So if my partnership deed specifies that if on the death of one partner, his legal heirs or his nominees can become a partner, then that partnership firm will not dissolve. Similarly, in case of, so the rights of legal representatives, which is the next point, is the same thing, that after death of the partner, their legal representatives have the right to receive share of partnership assets and right to participate in the winding up process. So if they are not made partners of the partnership firm, they are entitled to receive the share of profit of the partner who has died. But also when we come to liability of a partner in case of death, then in that case, the deceased partner's estate is not something which forms a part of the liabilities, or it cannot be used for settling liabilities of the firm. Settling accounts upon death of a partner, the accounts of the partnership need to be settled. This involves determining the deceased partner's share in the profits or losses of the firm up until the date of death. Continuing the partnership, this again is subject to agreement. If your agreement mentions that upon death of a partner, the partnership firm or the business of the partnership will continue, then that will continue. If otherwise, it dissolves. At the time of death of a partner, again, a public notice has to be given. A notice also has to be given to the registrar of firms, which we forgot to mention earlier. But whenever there's retirement or any change in the constitution of the firm, you have to intimate the registrar of firms as well. And the extract of the register is then changed, the entries are made, and then that comes into effect, the admission, retirement, or whatever the case may be. Liability of the estate, I mentioned earlier, the estate of deceased partner remains liable for any debts. However, personal liability of the deceased partners, legal representatives. So as I mentioned, for firms liabilities, the deceased partner's estate does not come into picture. However, for any personal acts done by the partners, his estate will be liable. Distribution of assets, after settling the accounts and paying off the partnership debts, the remaining assets are distributed among the partners or their legal representatives according to their respective shares as mentioned in the partnership agreement. Now, one more important question is that if a partner of a firm dies, can his minor son or daughter be admitted to the partnership firm? So the answer is that a minor can be admitted to the benefit of partnership, but he cannot be made liable for any acts on behalf of the firm or any acts done by him.
Now coming on to insolvency. Now this is a situation where if a particular partner has become insolvent, so the Act contains certain provisions regarding dissolution and winding up of a partnership. For example, if the partnership is actually facing a financial difficulty, then a dissolution is possible through the following ways. One is either by agreement, where obviously the partners mutually agree and they have an agreement amongst themselves to dissolve the partnership firm. The second is an expiry of a term or completion of a particular venture. So for example, as we said in the beginning, if a partnership firm has actually got a partnership deed, which is just for a specific time period or a specific particular task, then if that is completed, known as expiry of the term or completion of the particular venture, then the partnership firm can be dissolved because it was anyway set in place only for that particular aspect. Third way can be by a notice. A partner can give notice to other partners of their intention to dissolve the partnership. So for example, if one particular partner feels that the partnership firm should be dissolved, then he or she is allowed to give notice to the other partners. And then again, if they are all in agreement, it can be dissolved. Fourth way can be by death or actually becoming insolvent itself. So if a partner dies or becomes insolvent, then the partnership is dissolved, which basically means that if, for example, there is a partnership in which one person dies or a particular partner has become insolvent or the firm as a whole has become insolvent, then you can actually dissolve the partnership. And again, even in this type of situation, you will have settling of accounts where once the partnership is dissolved, the accounts of all the partners have to be settled. It involves settling the partnership's affairs, your realization of assets, payment of debts, and the distribution of remaining assets amongst the partners. Then the the payment of debts. Now, of course, since the partnership is being dissolved, they cannot evade liabilities which actually are on the head. So therefore, the debts and liabilities have to be paid off from the partnership's assets when they are actually being dissolved. Then a realization of assets, as in the assets of the partnership, meaning the property they own, the investments, all receivables which they are supposed to get. All these are liquidated or sold to actually generate funds to settle your debts. So in short, all of these things, including the last point of distribution of assets, they all cover up the same normal contractual obligations that we are aware of, that once you actually are dissolving a particular partnership or you're letting go of a particular contract that you have to see that all the rights and liabilities which existed in that are actually duly fulfilled by you and your obligations are as such completed. The same goes for a partnership firm as well.
Yeah, this is a very important feature of the Partnership Act, that partnership firm can be dissolved by a number of ways. So this can be bifurcated into two sections. One is without intervention of court and one is with court order. In without intervention of court, there is dissolution by an agreement. So if all the partners of a partnership firm agree and by express agreement, they agree to dissolve the firm, then there can be dissolution. Then second is compulsory dissolution, in the sense that all partners of a firm either become insolvent or the business of the firm that is carried on by the partnership firm, it becomes unlawful due to, say, any act that is introduced or for any other purpose. So in these two cases, there has to be compulsory dissolution of firm, because if all the partners are insolvent, obviously the business of the firm cannot be carried further. Then there can be dissolution in the event of certain contingencies. One is that if the partnership is for a specific purpose, then if that specific purpose is achieved or that objective is met, then the partnership has to be dissolved. Then second is if the partnership is for a specific term or tenure. For example, if the Yazad and I enter into a partnership only for 2 years, then on expiry of 2 years, either it can be renewed or the partnership firm has to dissolve, either of the two. Then the next important point is that dissolution can also happen on death, can also happen on insolvency, and there has to be an adjudication from court that the partner is an insolvent. If merely there's a petition or if he files for insolvency, that cannot be said to dissolve the firm, basically. Then there's one more way or method of dissolution of a firm, that is dissolution by notice. So in case of partnership at will, merely by giving a notice in writing to all the other partners, the partnership firm can be dissolved. Now, if we come to dissolution by court orders, there are 6 points which covers the methods of dissolving a partnership firm. First is when a partner becomes of an unsound mind, when a partner becomes permanently incapable of performing his or her duties, when a partner willfully or persistently commits a breach of the partnership agreement, which means he's not complying with the terms and conditions of the partnership agreement, or he's continuously doing acts which are not permitted by the partnership agreement. When the business of the firm becomes unlawful, when it is not reasonably practicable to carry on the business of the firm due to some dispute among the partners, in any other just and equitable circumstances. So these are the 6 cases where the court orders dissolution, and on such an order being passed, the partnership firm has to dissolve. Of course, upon dissolution, then all the rights and liabilities of the partners which are mentioned in the Partnership Act have to be followed. That after dissolution, the partners have a right to lien. Then if supposing there is any premium which is yet to be paid to them, that has to be paid. Settling of accounts, all the creditors have to be paid back. All of that comes into this. Is the same thing by insolvency, death or retirement, expiry of term, completion of specific purpose, happening of certain conditions.
Okay. Now we'll go on to the important aspect of actually registering your partnership firm. So as I said right at the beginning, the registration of a firm is not mandatory, but it's always advisable, because otherwise you cannot actually sue a third party or sue in your own name. So for example, now the registration process as such, 2 aspects. One is the partnership deed and 2 is your application for registration. So now, of course, if you want to register a firm, you have to have a deed in writing. You cannot register a firm which is an oral agreement. agreement because that's just not possible. So your partnership deed has to be a written agreement which outlines your terms and conditions of the partnership. It will include all your relevant details, the name of the firm, name and address of the partners, the amount of capital contribution they're bringing, profit sharing ratio, loss sharing ratio, remuneration, and other relevant provisions. And once you have your partnership deed, which is actually prepared and signed by each of the partners, then you actually have an application for registration which is made. So once the deed is prepared, you apply for registration. The application should be made to the registrar of firms, which is usually the office of the district registrar or deputy registrar in your respective state. So each state will have their own particular authority to whom you have to go to register your firm. And in that sense, once your deed is prepared between the partners and everybody is in agreement with that, you can go forward with an application for actually getting yourself registered. Now, few documents that you require to actually register your firm. One will be the duly filled application form. Second is, of course, your partnership deed in original, which will be signed. Third will be the affidavit stating partners' details and authenticity of a partnership deed. Fourth will be your proof of address, for example, your Aadhaar card, utility bills, rent agreements, etc. And a prescribed registration fee, which will have to be paid while getting your firm registered. Now, after you submit your application, of course, there is a certain amount of background check that actually happens. So the registrar has to verify your documents and your records. And if he is so satisfied, then they record the partnership in the register of firms and you get a certificate of registration, which is used, which also has a serial number, which is basically your registration identity for the remaining time that the partnership firm is actually in existence. Now, as we both have actually said a few times, registration of a firm is not mandatory, but there's obviously benefits to it. One, directly by registering your firm, you have your own legal identity. You can sue or be sued in your own name. You can sue a third party in your own name. It makes this easier to enforce your rights and obligations. Now, for example, if a partnership firm is running and there's a certain amount of money which has to be recovered by a person, from a person, sorry. Now, if your firm is not registered, it is impossible for you to actually file a suit against that person for the recovery. Because since you do not have a registration, Section 69 of the Act will actually come in as a bar and will not allow you to file the suit to get your recovery. So in that sense, obviously registering a firm makes more sense. Secondly, evidence. Now, a certificate of registration obviously is a conclusive proof that your partnership firm exists. It can be used as evidence in cases of disputes, legal proceedings, or for that matter, it can be used for any even correspondence that you actually have. Having a certificate of registration means you can actually mention on your letterhead that you are a registered partnership with your serial number, which helps you for your identity as well as for evidence purposes. Now, partner disputes. Now, as we said, you cannot sue or be sued in your own name if you actually are not registered. So if there are disputes amongst partners or between partners, if it's just two people, then in that case, you cannot file a lawsuit if your partnership is not registered. So because of that, you need to make sure that your firm actually is registered, and which is why it's said that it's always a beneficial thing to do. Because, for example, in the example that I gave, if it's Ruchi, myself, X and Y running a firm, and X is not behaving properly or is acting in breach of the terms, Ruchi, Y, and I will not be able to actually file a suit against him unless we have a registered firm. So in that sense, it becomes important to get your firm registered. Now, certain other points which also help with registration is your third-party relations. As I said, the confidence and credibility that you get by being a separate legal identity and having evidentiary proof that you are actually a partnership firm that is registered. It helps you when you go to a bank, financial institution, or other entities that deal with registered firms. For example, even if you seek to get a loan, or you actually advance a loan on behalf of the partnership firm to somebody else, then your third-party relations become much more stringent and actually straightforward or streamlined in that manner if you are registered. Now, tax benefits. A registered firm is eligible for certain tax benefits, like deduction of interest on partner loans and distribution of profits among partners. Now, in general, when there are so many particular aspects of tax-related law that exists, if you're getting a tax benefit by being registered, then naturally a firm would prefer to be registered instead of being unregistered. Now, expansion opportunities. Now, this goes on the same footing of third-party relations actually, and the fact that if you have your own legal entity and your own identity, then obviously it becomes easier for you to actually, in that sense, sell yourself or sell your partnership firm to grab business or to have collaborations in future. So such expansion opportunities is obviously easier as soon as you get registered. So which is why we end this slide with this line saying that although registration is not compulsory, it's always strongly recommended for partnership firms to enjoy these benefits and to protect their interests. And effects of non-registration. section 69 particularly, which actually says that you cannot sue or be sued in your own name if you're not registered. There are also certain rules which exist in the Partnership Act and provisions with respect to effects of non-registration. And Ruchi will just go through those particular points.
So there are, I guess, 4 rules in for this section. Firstly, it is that if you want to enforce your right, no suit can be instituted if your firm is not registered. While it is arising from a contract or conferred by this act, can be instituted in any court by on behalf of person suing as a partner. This is the same thing as Yazad already mentioned, that if you don't have a registration or a valid registration, the partners or the partnership firm cannot sue in the firm name. Second is that no suit to enforce a right arising from a contract can be instituted in any court by or on behalf of a firm against a third party. So even if you want to file a suit against a stranger or person with whom the firm has dealt with, that also cannot be done if your firm is not registered. Then the third rule says that provisions of rules 1 and 2 apply also to a claim of set off or other proceedings to enforce a right arising from a contract. Now, last rule is that the above rules do not apply to firms or to partners in firms who have no place of business in India, or to any suit or claim to set off exceeding 100 rupees in value. So these are the basic 4 rules which you have to keep in mind for if there's a question with respect to effect of non-registration.
So Yazad and Ruchi, what is the basic difference between winding up and dissolution?
Winding up is in case of companies, whereas in dissolution is applicable to partnership firms. So of course, for voluntary, if you refer to the Companies Act, there are various provisions like voluntary winding up and winding up by court order. Similarly, in case of partnership also, there is voluntary winding up where not winding up, actually dissolution, where the partners voluntarily decide to dissolve the firm in the cases as already specified in our PPT. So in case of those contingencies, the partners decide to dissolve the firm, then in that case it is called as a dissolution. So basically the difference is that winding up is in reference to a company and dissolution is in reference to a partnership firm.
Yeah, as per law, winding up is under the Companies Act. Here it's used more in an English term sense that the partnership firm is basically now dissolved. It's known as dissolution. And because of that, the business is wound up. But actually winding up as such in law is for a company. That's the basic difference as well.
Okay. Can a property be bought in the name of a partnership firm?
Yes.
Yes.
It can be bought in the name of a partnership firm, but then that property will be an asset of the firm. Of course, this is why the principle of agent and principal, and also if a property is brought in the firm's name, then a partner cannot exclusively deal with the property. So for example, if that property is purchased in the firm's name, and if you want to sell it off or alienate or mortgage or dispose of that property, then you have to take consent of all partners before doing that. This is why if you supposedly are looking for a property and you buy it personally and not in your capacity as a partner, you will have the right or authority to dispose or alienate. But in case you're purchasing it in firm's name, then all partners' consent is required.
Okay.
My query is regarding the registration of a firm. Typically, what happens is when you file a application for registration, it takes many times too much time. Say sometimes it takes even a year. So in that scenario, what happens if the other party files a claim against the partnership firm? Would it be treated as a registered firm or an unregistered firm?
See, until your firm is actually registered, you are an unregistered firm. So in that sense, only after you get your certificate of registration and you actually have your serial number of registration, can you actually be sued in your own name as well. Up until then, you cannot sue in your name or get sued in your name as well. Because, for example, if a third party is trying to sue you, there is no partnership firm which is registered for them to sue as well. So there can be no suit actually instituted also.
Because the partnership firm is not in existence only. So if you're dealing with any third party, it will either be in your personal capacity. It cannot be in your official capacity as a firm. firm because you are intending to come together and go for registration of a firm or whatever. But basically, your partnership firm comes into existence when you get a certificate of registration. Until then, there is no firm and there are no parts. So then in that case, you will be individually liable for all the acts that you are doing.
Because I remember there's a circular on the registrar of firms that once you file an application within 60 days, they are supposed to register it.
Okay.
So if they don't do it, because typically, practically this happens, they take their own sweet time.
Now that's a departmental issue with respect to the register. I'm assuming that you are speaking on like from Maharashtra or Mumbai itself, or from wherever.
Mumbai.
The point is that now that's a
Mumbai.
departmental issue, which whether they delay it, why they delay it, I mean, why the time constraint is not being followed or something. Now that is, I mean, I don't know how to give an answer for why that might happen or what might happen. But the basic aspect is that until you are actually registered, you cannot sue in your own name or get sued in your own name. So that is, I mean, as per section 69 of the Act itself. So in that sense, to answer your question from that limited aspect, at least that would be the answer.
What are the provisions pertaining to valuation of goodwill of a partnership firm when a partner is retiring?
So whenever there is retirement or say dissolution, there is a revaluation done of all the assets of the firm. So valuation of a goodwill per se will be done either with the valuation of assets by an independent valuer, or because of course when a partner is retiring from a firm, valuation of his goodwill, of his share in profits will be done, but the provision in Partnership Act we'll check.
Somebody's asked, can a person limit his liability under Partnership Act? Now, I mean, with respect to that, your liability limited in the sense that you are jointly and severally liable for everything done in that partnership firm. So you cannot say that I am, say for example, if there is a partnership with 4 people and I am a partner in that, and everybody has equal profit sharing, which means I have 25% profit sharing ratio. I cannot say that I will be liable only for 25% of the business or for 25% of wrong acts done by somebody or something like that. I am liable for the entire partnership as a whole, and the same goes for all the remaining 4 people, which is why it follows the same way that, for example, in a partnership of 4 people, if one person has done a mistake, that mistake bears liability on the entire partnership, not just on that one person. So it flows the same way that you cannot limit your liability to that extent where you say that only I am going to be liable from this partnership firm and nobody else will be liable. If such a situation does come and, for example, such a dispute arises between partners, then more often than not, you will either have a dispute going to court or you will have a reconstitution of partnership deed done wherein the remaining 3 may want this one person ousted. And obviously, it will have to be as per the provisions we said. Otherwise, he will still continue to be a partner even if you do not want him to.
It's section 55 of the Partnership Act, which deals with valuation of goodwill. So like I said, that at the time of settling of accounts, your valuation of goodwill will be done along with valuation of asset. And then accordingly, whatever share comes to you will be then distributed and divided accordingly.
What would be major differences between a firm registered under the Partnership Act and a firm registered under the LLP Act?
So a firm which is registered under the Partnership Act, one of the important elements for a partnership firm is that the liability of partners is unlimited. Whereas in case of limited liability partnership, the name itself suggests that the liability would be limited, which means that the personal assets or the partners, the designated partners of the limited liability partnership would not be personally liable. Their personal assets would not be involved in for supposedly settling debts of creditors or for any other liabilities of the firm. That is the major difference between a partnership and an LLP.
Also, just one more point, an LLP, since it's a limited liability partnership, but it is still having some bearing under the Companies Act as such, you can see that an LLP is always a separate legal entity, wherein even the LLP can be sued in its own name without individually everybody else being involved, as in the directors. But in a partnership firm, if you're suing the partnership firm, you are actually also suing the partners of that partnership firm because they are all jointly and severally liable to it. It may be a separate entity because it's been registered, but a partnership firm in that sense is the partners themselves. It's not separately like an LLP is where the assets and everything will be looked at a different angle. That is also one distinction. I hope that did answer your doubt.
Yes. So actually, I want to relate my first question with this answer itself. So if I'm a firm registered under the Partnership Act, can
Okay.
I limit my liability?
See, if you are registered under the Partnership Act, then you limit your liability in what aspect are you saying? Are you saying that the partner, say 4 partners may say one partner is limiting his liability, or are you saying the partnership as a whole is trying to limit the liability?
As an individual partner and not as the whole partnership firm.
No, not. That will not be possible because a partner is bound and liable
It is
severally.
subject. It is subject to what the partnership agreement says. So if your partnership deed specifically mentions or expressly mentions that this particular partner will not be personally liable for acts of the firm done in the usual course of business, then it will be taken in that sense. But if there is no such provision, then of course liability of a partner is unlimited. But if your partnership deed mentions that it is limited only to your share or your contribution in the partnership, then it will be that.
Can we say that then in that case, partnership deed would prevail over the provisions under the Act in case of a dispute? In case of a dispute.
No, the Act itself will specify in that particular provision that unless the contract expressly otherwise mentions. So in that case, if there's a provision saying that unless there is a contract to the contrary, the liability of partners is unlimited, then you can refer to the partnership.
But your partnership deed in general also is, stemming out of your Partnership Act. So in that sense, you cannot have a partnership deed made for example, like just a random example. You cannot have a partnership deed where partners are agreeing to conduct criminal activities. Even if there is a particular thing where you are in agreement and everybody says that we are agreeable with such and such profit sharing ratio to start some rioting activity or some other criminal activities. That will not be allowed even if everyone's in agreement. So your partnership deed cannot override the provisions of the Act in that sense. That will always be there.
So in case of a dispute, if I have limited my liability under my partnership deed and a dispute happens, then I can of course take a defense of that provision under the agreement.
See, your LLP, it will firstly depend on your LLP being registered under what. Now, an LLP, as you know, there's an LLP Act separately. The
Right.
Companies Act also mentions LLP. Partnership also mentions LLP. So your relevant place where you are registered or what you actually are operating as is what will come into account. If you're registered as a company, then you are not a partnership in that sense. You're registered as a company where your LLP will have directors. If you are as a limited liability partnership here with partners, then your partnership provisions will also apply. So that is one aspect which also has to be looked at. Because if you're a company, then of course you do not have partners in that sense who are liable. The assets of the entire company as a whole are looked at and not anybody's individual assets. But you're in a partnership, you saw that even your own partners, individual assets in that sense do come into play because the partnership as a whole is not got separate assets of its own or whatever. It's in the name of those partners who are actually running it.
So it will be definitely case to case basis if I'm a registered.
It would.
Yes. Okay. Thanks a lot. Thank you.
In case of company, the accounts are prepared under provision of Companies Act. Likewise, in case of firm, the accounts of firm be compiled under which provision of the Act. Now, if I'm not wrong, I think section 48 deals with settlement of accounts. I'll just check that. But 48 or 49. But in that sense, see, your same way as your Companies Act has accounts prepared under those provisions. Your Partnership Act also mentions provisions for actually getting your account settled. And as we said in the slide also in multiple places, settlement of accounts happens at multiple stages in a partnership firm. At admission, at insolvency, at dissolution, at retirement, at death, at all these stages, you actually have settlement of accounts done. And that happens as per the provisions of the Partnership Act itself. So Manoj, your question's answer will be that the accounts of the firm will be compiled under the provisions of the Partnership Act itself. For which provision exactly? I think it is section 48. I will just confirm that once. Yeah. 48, 49, and 55 are rules for settling accounts after dissolution. These are those sections. I was asking in the sense which accounting standards are applicable. Your general provisions of accounting as such, you will have to maintain your partnership accounts in AS or AS.
Indian accounting standards or accounting standards. Of course, Indian accounting.
See, Indian accounting standards will apply. It's an Indian Partnership Act. So in that sense, whichever accounting standards are applicable in India, that is the one that you will have to actually follow. And that goes for all businesses as a whole, whether it's a sole proprietorship, partnership, company, whatever it may be, you will have to follow the accounting standards that are prevalent in India itself.
Because if supposingly an entity is registered in India, within India, is carrying on business within India, then whatever provisions or whatever regulations as per Indian accounting standards, those will be applicable to all business entities in India.
My question is that you mentioned that by registering a firm, it gets the status of separate legal entity. So, does the partner get any kind of protection if the firm is getting status of separate legal entity apart from the benefits of registration? Does the partner gets any protection under the eyes of law? Or
See, the very fact that once you register yourself, you actually are able to start suing in your own name or getting sued in your own name, itself is the actual benefit that they do get. Because, for example, as we said, now there are various benefits of registering yourself for the partners and for the partnership as a whole. If you want to boost your business as a partnership firm, or you want to collaborate with somebody else, with another partnership firm or some other entity or whatever it may be, or you want to actually just in general reach out to third parties, doing it as a registered firm becomes easier for you. And since it becomes easier for the firm to do it in its name, as we've said repeatedly, a partnership firm is nothing in its name except for those partners themselves, because they are the ones running it. So in that sense, it definitely has a big benefit to the partners themselves if they do register it, due to all of these aspects. The liability though would be the same, because for example, if you have four partners registering a partnership firm, just because it is registered, it does not mean that their liabilities change. Their liabilities will still be as per the partnership deed which has got registered, or it will be as per their agreement, or sorry, the agreement is the deed, or it will be equally if there is no actual specific mention of the profit sharing ratio. So just because it gets registered, there is no change in the liability as such that arises.